Welcome back to another edition of the Dirty Verdict Podcast. I'm the solo host tonight, Peter Taff, not joined by Bill Ogden, not joined by Kyle Herbert, as they are taking a summer break with their children on vacation. So miss you guys, and y'all are going to miss being here for this one for sure. So we are fortunate enough to have Thomas Frashier from the esteemed law firm of AZA, the AZA law firm here in Houston, Texas.
Thanks, Peter. Pleasure to be here.
Yeah, thanks, Thomas. We got a lot of stuff to talk about. The prime thing that we want to cover is this first of its kind influencer copyright case that your firm handled for the defendant. And by first of its kind, it is involved one influencer, Austin-based, suing another influencer, also Austin-based, claiming the defendant was misappropriating, and maybe not, that's legal, that has legal significance, that term, but for the layperson, I've got a trademark, I've got a vibe, I've got a style, and the defendant is stealing my style on her social media posts.
Specifically her beige style. Yeah, that's right.
More specifically, sad beige.
Sad beige, that's right. We had a lot of people calling the sad beige lawsuit.
Yes.
So yeah, that's the heart of it, and it was a really interesting case to get to work on.
Yeah, and so there's, I definitely, I'm interested in the legal aspects, but there's a lot of stuff that's interesting. I mean, obviously, it garnered a lot of press because it's interesting to the non-lawyers too. So we'll kind of go in and out of some legal terms, and if you ever there's some term that's a high-level legal term, if you can kind of break it down a little bit, and I'll prompt you. That's kind of my role here sometimes, is I'll prompt the lawyers to.
Absolutely. No $5 words.
Yeah, there you go. Okay. So we're going to talk about that in detail. First, what I wanted, though, just a quick background on you. Where are you from originally?
So originally from, born here, but I grew up in Allen, Texas, just north of Dallas. So went to Allen High School and grew up, then went to Southwestern University in Georgetown.
And there you were a swimmer and a singer?
That's right. Both on the swim team, and then scholarship tenor for all 4 years, actually. So
awesome.
That was a ton of fun. Did a little opera theater as well.
Good. Okay. Well, like I said, I would keep thinking of what my co-host would be asking. You'd be singing opera. If they were here, they would press you like every 5 minutes to sing opera, but I'm not going to do that.
It wouldn't be
unless you want to.
Usually it takes at least the third glass of wine or vino in Italian, and then the Italian comes out.
Oh, good. Do you speak Italian?
I sing some.
Oh, good. Okay. And then did you go straight to Michigan for law school?
I took a couple years living in Austin. I worked as a market research analyst in the utilities sector. Decided that trying cases might be a little more fun than that. So started studying for the LSAT. Frankly, I didn't know how to get into law school. So then a couple of my buddies ended up going, and after that, applied and got into Michigan.
And I thought you were going to say you'd always wanted to be a lawyer because of our off screen conversation. It sounded like at least in college, you demonstrated a knack for it.
That's right. So there was sort of an incident that ended up being interesting. My senior year, one of the fraternities on campus, all of their members were kind of accused of this vandalism crime that they just didn't commit. A rock had been thrown through a window, and the chief of police kind of wanted to hunt someone down, hold someone accountable for it. And he says, well, I think the KAs did it, so I'm going to accuse the president, vice president of doing this, and I'm going to charge every single other member of the chapter with conspiracy and impeding a police investigation because you won't confess to something you didn't do. So the university actually held a jury trial. We had a jury of 3 students and 3 professors, and I got to, through the president, cross-examine that chief of police. That was pretty much the whole trial. It was only about 10 or 15 minutes. And then, not long after, very short deliberation, they were found acquitted of all charges.
Good. But you weren't totally sold on the law at that point. You wanted to check out some other stuff.
The truth is I had no idea how to get into law school. Prior to, practicing now, I had maybe spoken to or met 3 or 4 lawyers. So I had a couple of my friends talking to them as they're getting into law school. Hey, there's this thing called the LSAT. hey, you can get a scholarship for law school, which I had no idea about. That was kind of the goal originally out of school, was spend some time working, stack up some money, to eventually pay for school. Found out that scholarships, loans, and that type of thing were an option, and then really just applied myself to studying to, finally go pursue that dream, because it always had been on my mind.
Yeah. And then you obviously did well in the LSAT in undergrad, because Michigan's a fantastic law school.
I was very happy to go there. It's a fantastic law school, and frankly, only 2 years ago, even better football team.
Yeah.
That was a ton of fun to get to go, and it weighed heavily in the decision of ultimately where to go, I'll confess.
Yeah, I'd never been to Ann Arbor until Texas played there last fall, and it was awesome. I can see why people love it.
Look, the student visit day, we end up getting a lot of students to finally commit. You get to go to the big house, you get to see what it's going to be like, and I decided, you know what, I can put up with 3 winters for that.
That's the downside, right? You just tolerate 3 months, basically.
The law school schedule when you're going to Michigan and you're from Texas is just about the worst, because you're spending winters in Ann Arbor and summers in Houston, and you can't design a more challenging weather schedule unless maybe you're going up to Buffalo or something.
True. But yeah, it's nice. Okay, so did you go straight from Michigan to AZA?
I did. So, the funny thing, I didn't know lawyers before law school, didn't know anything about what the practice was, other than I kind of had the vibe and sense I wanted to do it. So you get to law school nowadays, and they tell you what I think is a true and pretty practical reality, which is most of y'all aren't going to try cases. Cases aren't really even tried anymore. So for all of you, folks at Michigan, at all these other schools, don't think about your career in terms of trying cases, in terms of actually getting in front of a jury. Think about it in terms of serving your clients, lower your expectations. And then John Zavitsanos from AZA, all I knew about him was that he was bringing the best lunch in town, Zingerman's Deli, and he was going to talk about trying cases. So I decided I'm going to go to this lunch talk, and he gets up there kind of like a maniac for an hour going, here's a deposition clip, here's a trial clip, where, it's just him leaning in. He loves cross-examination and, just kind of doing what he does best, showing off for an hour and saying, and if you want to have fun like this, if you ever want to try a case, you got to come to one of these Houston, litigation boutiques, because when it comes to these, large commercial cases, obviously, of course, criminal side, you can try a lot of cases. Personal injury, there are a lot of cases to be tried. If you're on the plaintiff side, for sure, you can jump right into that. But especially on these commercial cases, if you ever want to try one of those, you got to come to a place like us, where we will give you that early responsibility, let you jump in and try the cases. So I said, sign me up. And I spent actually both my summers at AZA before joining them.
Did John have a Michigan connection, or why was
both John and Joe, our founding partners, both Michigan grads? So we always end up going up there. Frankly, maybe they go a little easier on us if we were from Michigan, or lower the bar. Maybe that's how I got in. But I'm very happy I ended up at AZA.
Good. And I was going to say, I'm just looking at your bio, lead counsel in a multi-million-dollar business valuation arbitration in California. Another one, multi-million real estate arbitration, trial team for a $28 million verdict for recognized as top 20 plaintiff verdict in Texas in 22. So you're getting after it.
That's sort of the promise that AZA makes to folks when you're looking at joining. Most of our summer associates have options, and we encourage people, split your summer, go check out all the options, decide if you want to come with us. But, the promise we say is you're going to get to try cases. So that $28 million one, that was the Port of Houston trial. I think it was 3-4 months after I had formally started at the firm. So, I've been practicing for all 3 or 4 months. We have all the expert depositions coming up, and they say, hey, go ahead, go take those depositions. So got to jump in, take the expert depos, turned around and immediately, was working up the opening. I think that case, we were in front of Judge Hughes for that case. And so civil trial lasted about a week. And it was just a wild ride. So a ton of fun to get to jump in. And then that weekend, I actually jumped on a plane, flew to Chicago, and was going to be taking the lead-off witness in a different trial in a federal court up there.
Wow.
That one, we won it on the courthouse steps, but that was kind of the whirlwind. They kept the promise that I've been getting to jump in and try cases.
So, I mean, the firm practices really nationwide.
Oh, yeah. I've tried 2 cases in the state courthouse just up the street, but other than that, Delaware, California, Chicago, couple different hearings and matters, Louisiana. So really getting to travel a little bit for work. It's nice when you're trying a case in front of a judge, right in your backyard, but it is fun. We get to tell people, hey, wherever your case is, we've tried a case there.
Yeah.
So that's good.
Good. And I follow AZA on all the, social media stuff. And so, there's posts of y'all constantly in trial.
No one will accuse us of not liking to brag about us, brag about ourselves, and how much we like going to trial. I think it was actually just this April or May, we were walking up the street to the courthouse, and we had 4 trial teams all in trial. So it was literally half of our lawyers walking up the street, and someone in a building had kind of gotten a picture of us of just, here's 12 lawyers all walking to the courthouse. And, that was kind of a fun moment that we were all at trial all the time. During lunch, we would all go to the breakout room up on the top floor, just all have lunch. And, we're a firm of people who love trying cases. And so it's a lot of fun to be part of that culture.
Yeah. Yeah, for sure. I think I was watching there. John was in a long trial. I think probably that was stream. I try to watch trials, ask every judge, please stream, because it's very helpful.
No, we love getting to watch that. As a young lawyer, you're told all the time, if you want to learn how to speak well at hearings, how to be persuasive, connect with a judge or connect with a jury, go sit and watch docket day. Mm-hmm. But now, with docket days, mostly, maybe not mostly, but frequently it's all virtual. Frequently you're sitting in an empty courtroom, if they're holding it, or it's just rare and rare to know when trials are going on. But, we do try and go and sit and watch. It's nice to be at a firm, though, where, we've got our own cheering section. When a trial's going on, we'll go show up because you're getting to learn, and it's frankly just a lot of fun.
Yeah. Well, good. Yeah. You'll learn also what not to say in front of judges.
I've probably learned more, and I always tell, our new associates and summer associates, you'll learn a lot getting to be around, the best. You'll learn even more, in the lessons of what you should never do, because those lessons are usually learned hard and, pretty loud in front of you. Mental note, never do that.
And for all the world to see sometimes.
Oh, yeah.
Okay, well, let's get into this case. Again, this was reported nationally and definitely first of its kind. So your client is named Alyssa Scheil?
Alyssa Scheil.
Scheil.
That's right.
Okay, and she was sued. She was the defendant, so she was sued by another influencer named Sydney Gifford.
That's right.
Okay, and so
I think it's Sydney Sloan. She got married midway through the case, but caption still says Gifford versus Scheil.
Okay, and so influencer is a term that 10 years ago no one would know what you're talking about, but now it's a well-known term. However, it has different stripes to it. So these particular quote unquote influencers, what do they do? What's their model? What's their goal?
So the particular kind of influencing that they did was, while both of them do, social media, Pinterest and Instagram for different products, different services, and both of them sometimes coordinate with individual businesses, for probably 95%, both of these women's business was mostly working with Amazon through what's called the Amazon Influencer Program or the Amazon Associates Program. But basically the way that it works is you sign up to, be part of this program. And as part of that, there's an audition process. You have to create some shoppable videos, advertising, particular products. And then once you're approved, you get a link that every time you redirect someone to Amazon, regardless of product, for about 24 hours, I think, you're going to be getting tags of, hey, this person bought, 3 purses and a coat after being linked to Amazon through you, and you get a cut of that. It's different by product. It's different by the advertiser. But that was the vast majority for both of these women's business was they worked, they weren't employees of Amazon, but they worked pretty directly in this Amazon program.
Got it. And then, because you'll see that sometimes on social media where it's like, look how easy this is. You just block this thing here and you copy here and you set up a page and you just watch the money come in. And this is a much more robust, but I assume more lucrative program.
Certainly more lucrative and certainly more robust. I think for a lot of products, they have the simple, share link that anyone can kind of copy and drop in. This is another level, for the mostly women, but it's men and women of all ages, really, who are involved in this influencer program. For all of the folks who are involved in it, they actually have a liaison or a contact who's sending them emails, monthly or so saying, hey, here are different products that we, Prime Day is coming up. I actually think this is a very timely podcast.
Today is Prime Day.
Today is Prime Day. So we're right on the money for that.
Yeah. But it was exclusively with Amazon, or do they have you're setting up your brand. You may as well take it out for a spell.
They both had a talent agency and managers. So, individual brands would reach out to them. But, for both of them, the large quantity of their business, the large quantity of their posting was with these Amazon influencer program. And, basically the way that works is, you can advertise really any product that you want on Amazon. It's not necessarily the products that you're advertising, because you don't get money when someone buys the same pair of shoes that you just held up. Mm-hmm. It's directing people into that Amazon ecosystem. Now, they're probably going to go buy the shoes that you were just talking about. That's why they click that link. Mm-hmm. But, if they click that link and then they go buy a mattress, well, you can still get cut of that.
By just getting into Amazon.
Right. It's you're sort of tagging them and bringing them into the ecosystem. And then after that, you're getting some portion of the purchases that they make for, that window of time right after they click on the link.
And they have talent managers?
They do. It's actually very common. I didn't know about this very much before we started learning about this case, but, most famous people you've seen online, and it's not just limited to people, famous animals have talent agents. I'm pressed to think of one right now, but I'm sure. What was that little hippo? I don't know if y'all saw this.
No.
There was this little hippo baby that was really famous recently, or there was from years ago a grumpy cat, which is just this really grumpy looking cat, and they actually had their own agents because it's people who know how to keep that sort of social media ecosystem going for you off of your capital.
Yeah, I'm really sorry Bill and Kyle aren't here because, the good news is this would last like 5 hours.
There'd be a lot to cut.
Yeah, there'd be a lot. Yeah, there's just so much material here for them that that's probably a good thing.
Makes it a little easier on me.
Yeah. Yeah, you wouldn't, there's some things you just wouldn't be able to respond to. But, okay, so the vibe or the allegations were rooted in intellectual property. So as we know, there's trademark, copyright, trade secret. I don't think that was an issue here, but, and then patent, of course, those are all the different stripes of intellectual property. What was plaintiff is, arguing that defendant has taken something from her. So what is it that she alleged had been taken from her?
So the way we sort of thought about the case, there were 3 different main flavors that were being alleged here. And the first of those was really the one that attracted the most attention to the case, which was this, you stole my vibe accusation. And that was phrased both in terms of in copyright. She said, well, I took a particular picture that used a minimalist background with beige products, and I arranged them in a minimalist composition. Question what that means exactly, other than it's just the product on a white background. And you created a picture with sometimes the same product, sometimes a different product, but it was also beige. It was also cream. It was also on a white background. And that is too close to my aesthetic. So she phrased her copyright claims in that sense and alleging everything from it's copyright if you use a similar product, if you use a similar background, even if it's a different product. At times, it was a little hard to pin down what exactly the allegations were. They were, when we asked them, what actually are you alleging? They were a little all over the place. We can kind of get into that.
Mm-hmm.
But the next, the other sort of flavor is what's called misappropriation of likeness. And that's the idea in the law, right? Everybody has a likeness, which is generally your face. If you stamp my face on a product without my permission, you have misappropriated my likeness because people are going to think that I'm endorsing that. And I have a right to sell my likeness or to say I'm only going to endorse brands that pay me.
Mm-hmm.
So that's the other heart of it.
Let me ask real quick on that, because that comes up in the name, image, likeness, that NIL for sports. Now, and you used an example offline, if someone just takes a picture of Elvis Presley and puts it on the Dirty Verdict podcast, and here's a picture of Elvis, and we can't do that. That's not allowed.
Right. You can't, at the beginning of every episode, you can't pop up, the ghost of Elvis and say, Elvis Presley and his estate endorsed this particular podcast. If you did that, you'd be in trouble.
If I did that, what would their remedy be? They could get an injunction telling me not to do it, but could they get a damage award as well?
Potentially a damage award, usually like a reasonable royalty. They have to be able to say, hey, we sell our likeness. I'm sure Elvis or the estate of Elvis would actually have an easier time because I think
there's a market.
There is a market for the likeness and endorsements of Elvis.
Okay.
For any given person off the street, it becomes a much harder case.
Yeah. Because were these? So would it be? Not saying what. I'm guessing it's not it. Let's say a Prada bag. Were they both allowed to? Assuming Amazon under this influencer program was like, hey, can you push this Prada bag this week? There's nothing wrong with them both doing it.
So that was pretty much our case. And that was really how we thought about it. That sort of analogy that we frequently used was, I had a lot of classmates growing up in high school who went and worked as models for different clothing stores. And this kind of reminded me of a situation where, two young women go to work for Abercrombie. Abercrombie says, all right, here are the clothes we want you to wear. You're wearing Abercrombie clothes to bring customers to Abercrombie. And then one gets mad, like, hey, you're wearing Abercrombie clothes. What's the deal here? And, some of these products the women would go and find themselves. But there are a lot of them where Amazon is putting the products in their hands. I mean, we had the emails. If you look on Prime Day, I haven't even looked at it yet, but I can pretty much guarantee Nespresso is going to be one of their... It might be coming up on day 2, but it's always one of their doorbuster deals. They have a close brand partnership with Nespresso. And so you always see it in the inboxes. Hey, Prime Day's coming up. Order an Nespresso. Advertise it, please. And some of these products, they even get a higher commission for advertising. So there's a funneling in the system where the women aren't just creating the products or, deciding, hey, I'm going to be the first person to take this product to make it popular. It's actually the whole other way around, where the women are smart. I mean, they're looking at what are the products that are already viral and jumping onto those trains to bring it to an audience that would receive it well.
Yeah. I was just thinking, so this is, for anyone thinking about law, and most people think lawyers are boring, this is a great example of how every case is so unique, and you learn through the process. You now know what more than 99% of people, how this whole process now works in this day and age through this case.
Like I said, before this case started, I didn't know. I mean, I knew what an influencer was. I knew what TikTok was. I'm on TikTok. But I had no clue how this ecosystem really worked. That was another, I don't know if it was a challenge in the case. We saw it as an advantage, which was, the complaint and the allegations sort of distorted how this ecosystem actually works. Here's the other reality, right? Most of the products that were involved in this case, it's not like they're advertising Uggs. They're advertising a very particular Chinese brand of Uggs. They're not actually Uggs, but they're copying the Uggs. knockoffs is
Yeah.
the word most people might use, but dupes, I think, is what they call them nowadays. But they're mostly taking, luxury products at the, next step down, products emulating that at the non-luxury price and reaching them to an audience of mostly young women who can afford the dupe versions.
Yeah.
And so that was sort of the interesting thing as we were thinking about the strategy to gear up and try this case is, in a way, it is a case about, knockoffs and dupes. You're in this ecosystem where the day a product comes out, debuts in Paris, 3 weeks later, it's rolling off the lines in China. And we have emails are coming over from China, reaching out to women saying, hey, we'd love for you to advertise this product and it'll ship just in time. Mm-hmm. So it really was a fascinating, peek behind that curtain.
Yeah. So this is also kind of we have the law, and that's you file briefs and take depositions, but then there's a PR component to it. So when this lawsuit first came out, I guess everyone got their version of things. And I thought this because you said that you thought they misrepresented how things really work in that ecosystem. And then y'all get involved and the PR appears to change to where people are like, oh, okay, this doesn't make any sense.
We were pretty aggressive in this case, taking the story public. We wrote a pretty aggressive speaking answer to sort of set the record straight. In fact, the regular media really picked up on what we said, but we actually, even just in the legal media, we opened with I think it was a Beyonce quote in our answer, top of the caption, Beyonce quote, people are only hating because they're jealous that they're in the sunshine and it's raining on you. Something like that.
Who are you going to give credit on your team for coming up with that?
100% Shamir.
Okay. All right.
Yeah, no, 100% Shamir. He is the genius behind that. Shamir, it's a shame he can't be here today. He really has a flair for, the dramatic, for the entertaining. The guy has more friends in town pretty much than anyone I know. When you're rolling with Shamir, you're always rolling up with more of his friends.
Yeah.
But yeah, so time comes to file the answer, and we go pretty aggressive on the PR to set the record straight. And, it made a splash because people covered this case the day it was filed. And then after that answer, things really picked up. We had multiple, news organizations reaching out. It's funny. Most cases that I'm part of, you aren't talking to the media necessarily. Here, both sides are interviewing with, the Washington Post, with Mia Sato really wrote sort of the defining article in The Verge on this. And so there were frequent communications with media and that war going on, which is a different level than we normally think about a case.
Yeah. The Verge's story was called Bad Influence, which I think there's a link to it on your website where you talk about this case. Okay, so then, but this case was just filed like what, middle of 24, or was it older than that?
I think early middle of 2024, maybe April or so. That's right.
Okay, so y'all get in and immediately file a motion. Okay, so let me back up a little bit. This is the legal side of it. Yeah. What were their causes of action asserted against your client?
So there were 8 causes of action. Can kind of put them in buckets. We've got the copyright claims, copyright infringement, both direct and vicarious. The DMCA, the Digital Millennium Copyright Act, which basically that claim is, she said, hey, you created similar photographs and you didn't attribute me. Very close kind of gloss to the copyright claims. Trade dress, which I think I forgot to mention earlier. That's the other interesting sort of flavor, which is the idea of, I have a vibe. I have a very distinctive look that I am known for, that only I'm known for. Think of your favorite McDonald's restaurant. You've got the yellow designs, you've got the red, or a John Deere tractor. If I see a green and yellow tractor, I instantly know what it is. Recognizable. She said, you're violating that. That
would be, and I'm thinking, I'm going to channel Kyle. That would be the, from Coming to America. They've got the golden arches, we've got the golden arcs, or something like that.
Yeah.
That would be the protagonist or the dad of the lady in Coming to America. That would be a trade dress violation of McDonald's.
That's right. That's the essence of trade dress is, you don't necessarily have to exactly copy, an M. You could make it a W or even another letter, but it's dressed up and it's in the same font. We all know you're copying McDonald's when you do that because it looks exactly like them.
Yeah.
That's the essence of that allegation.
Kind of like we've talked about a lot of Buc-ee's cases. They've been very aggressive in policing their IP.
Yeah, I've seen some interesting ones where, full credit to them. I see this, cartoon looking beaver at a gas station down in Mexico. That ain't Bucky the beaver, but it's pretty darn close. Yeah. That might be in multiple flavors, but trade dress is certainly part of it.
Okay. All right.
The other interesting one was likeness, misappropriation of your likeness. Yeah. So like we said, that's your face or your name or a very distinctive voice. Celine Dion, Beyonce. If you emulate, use an AI to make a voice that sounds exactly like them, well, okay, you can't do that either. Here, she was really alleging it's her face. Two women next to each other. And to state the claim, you got to say, people can't tell us apart. She's posting things, and when people, even my mom or my brother, my family, look at it, they can't tell us apart.
They're photographs. They're pictures of their faces.
Photographs and posts, pictures of their faces. And I mean, in this case, it was highly relevant that, the plaintiff who was suing she appears white. Our client does not. She's a Black Latina woman. They did not look the same. And so, that was part of our point there is it's pretty incredulous to say, well, people are getting us confused when we post, these two pictures side by side that clearly are not the same person.
Now, would that, though, as preposterous as y'all think it was, would that be still a fact question had it gotten that far?
So the ultimate question, right, of confusion there, yeah, that's a fact question. I think it is one that the court, could inspect on, is it plausible here? If you have pictures in your complaint, maybe. Here, the court decided to focus just on the words in the complaint. So they said, well, they've alleged that people are confused and we're not going to squint or look at those pictures.
Yeah, that would be an interesting one because I think in the big cases, people will typically get surveys done by experts to demonstrate whether it was confusion or not. Here, you'd almost be like, why do I need to get an expert, to say something that's so evident?
Well, there's two ways, right? Because that actual confusion is usually at the heart of this claim and other types of claims. It's people are truly confused. Mm-hmm. And, here they said, well, we have direct evidence of that. People reaching out saying that they're confused. So we said, great, produce it.
Yeah.
We'd love to see that. Maybe one of the reasons this case went away is we never saw anything substantial. And, when we kind of needled them for it, said, identify.
Yeah.
Who told you that? Well, my mom, my sister, my brother, like, okay, hold up. Oh, and my best friend. We weren't finding all these random people who were actually confused.
And or did we cover the cause of action?
There were three other causes of action: tortious interference, unfair competition, unjust enrichment. Frankly, talking a little bit of legalese, in federal court, they were preempted claims, so the court just kind of threw those out. So they were the belt and suspenders claims where, if you're flipping through the manual going, well, what's everything in the book that I can throw in the kitchen sink here? All right, those were kitchen sink claims, but in federal court, when you've alleged trade dress, copyright infringement, I think it's the Copyright Act actually preempts those. So the court just says, we throw those out when you're in the same case like this.
Got it. Okay. Quick side question. There's a advertisement that I hear in Austin a lot. I think it's a radio station. It's on the radio. It's for a car dealership. And they've got Bill Clinton and George Bush kind of impersonators that maybe really at this point, like anyone under 30 wouldn't know what they're trying to do, but anyone obviously over 30 would be like, oh, that's
right.
A fake. But it's not close. It's just enough to where you're like, oh, they're trying to do Bush and Clinton. Is that something, though, that would be, when you're talking about Celine Dion, is that something that if President Bush and President Clinton really wanted to pursue a small, car dealership, that they could for that kind of thing?
They couldn't. For that example, a couple different reasons. I mean, the main one there being everyone's going to hear their voices and go, okay, this is a Bush impression.
Yeah.
No one has a monopoly on their own impressions. I'm sure there are a lot of celebrities who kind of wish they did, so you couldn't make fun of them. But, parody, free expression, that's all protected under the law. You don't have a monopoly on, put it this way, if you had a monopoly on that, right, you could sue anybody who ever talked about you or put a picture up of you in an unfavorable news story. That's not protected under the law. We're allowed to talk about you. We're allowed to make fun of you. And we're allowed to joke around with even a distinct voice. Because the other thing is nobody's going to really be confused that they're actually endorsing that product. And there's kind of this inverse way. The more famous you are, the more valuable, your likeness is. But there's also the more practical reality that we know, come on, did George Bush really advertise this random car dealer? Or it's obvious parody.
Yeah. Well, Josh brought up a good point offline is with AI now, though, you could get an identical voice. And the question, that will probably be the next new case of its kind, lawsuit.
It wouldn't surprise me if there already are some deepfake. I don't know why I have it in my head that it's Scarlett Johansson. I think there is a deepfake case where she says, someone manufactured my voice. And the AIs that do that are actually really good now. You'd be surprised whether you'd be able to tell or not. And, there are even the ones, we're pretty close now to where they can actually create a face of that person from known images and make them speak. We're not far from you can create a very convincing deepfake. I know there are cases of that in multiple different fields.
Yeah. Yeah, I just saw today in the news that someone has got a deal with Marco Rubio. This is kind of scary, where they've done this with Marco Rubio's voice, the Secretary of State, and have him calling like actual world leaders, and it's kind of a problem.
That seems problematic.
Yeah.
I don't know that the deepfake AI should be, negotiating politics of state, but AI is going to be used in a lot of new spheres. That's the easy one.
I just use it to make baby videos for the podcast of Kyle and Bill.
We make pretty silly images sometimes of our partners and pass them around. We've definitely put them, doing a slam dunk. And let me tell you, I work with my bosses. They can't dunk anymore.
No.
I don't know.
I wouldn't advise it. Even if they could, it's not a good idea.
Yeah.
Okay, so damages, their relief, not just statutory damages, if there's injunctive relief. So one, I was along those lines when you were talking about the affinity program or affiliate program. Did they document any instances where someone thought they were buying a whatever fake Uggs or knockoff Uggs through your client's site when they meant to go through the other lady's site?
We never saw the proof of that, and we were looking for it pretty aggressively. The kind of this point too, when we pressed them to say, well, what really are you saying is the problem here? What really are you accusing us? If we're going to give you something, if we were to reach a settlement or an agreed injunction, what would it say? And that was always a problem in this case because, they would articulate to us, well, you can't copy us. Okay, we obviously disagree about what that means. We're in a lawsuit. What do you mean? Well, you can't post products that are similar. Well, what do you mean by a similar product? And then they wrote it out for us. And they said, well, we would like Ms. Shield to stop advertising products on Amazon that are beige or any other color when Sydney had advertised them first. And the language that they kept giving us and saying, here's our demand. Well, it was, you can't advertise a product from a particular manufacturer, whether or not it's the same product, whether or not it's the same color. So the moment she, does a jacket of any kind, you can't advertise jackets anymore. I mean, there are layers and layers of problems with that. How are we supposed to know everything you're advertising? But to me, it's even crazier, right? It's like, this is like if H-E-B and Walmart got into a lawsuit because H-E-B says, well, we cultivate a very curated snack aisle and we like to make sure we have what our customers like. We, stock 2-liter Coca-Cola. We have the nacho Doritos and, Goldfish. Well, Walmart, you sell 2-liter Coca-Cola, nacho Doritos, and Goldfish. You're copying us. You can't sell those products too. That's not how the free market works. And so, all the injunctions they were seeking were basically a monopoly, which is part of why, the case had to be litigated.
Yeah, it was almost like a reverse monopoly because she's saying, I guess everyone else in the world can do it, just not your client.
Well, that's the crazy thing to us, right? To file these claims, you have to go and file copyright registrations. And here, the only copyrights that we're aware the plaintiff ever owned were some instances where she alleged that we had posted products second. Now, it's funny, actually digging into that, a lot of the products, even the ones that are listed in the complaint, probably the best thing they ever did was take everything side by side, and it looked pretty good until you pull those pictures. We had the metadata. We could prove that we actually took some of those pictures first. The post dates were later, but she had, queued up her information. So, that was some of the crazy stuff to us.
Yeah. Okay. So you talk about the injunctive relief. Did they have a damage model of how she'd been damaged or how she should be compensated?
They put forward a model. To us, it wasn't terribly convincing, and they never had a real expert for it. But there are sort of two sets in a copyright or infringement claim, right? There are actual damages and then statutory damages. So they did allege statutory damages. They never put a specific number or amount in front of us. But
what would those be? Like, is it like 5,000 in infraction, or
if you take the complaint at pure face value, that there's a sort of a punitive modifier if you're a willful infringer.
Mm-hmm.
And they say, well, we gave you notice that we thought you were copying us and you continued to post. So you're a willful infringer. All right, well, they put 70 works or something at issue, 50 to 70. So if you go by post, add the willful infringer, maybe it could have supported almost up to $1 million of statutory damages. I think that number is purely hypothetical. And the other big problem that they had is that in the statute, you actually have to register your works quickly. You can't linger about, let all your stuff sit online, and then decide, oh, I'm going to sue this person and go register them all at once. So it's called the 3-month rule. If you didn't register within 3 months,
first use,
that's their publication.
Yeah.
If you didn't register in 3 months, you don't get statutory damages. So most of the ones in this case violated that rule. So they were left with actual damages. And here, what she said was, I think you were copying me in this window roughly of December 22 to 23. I happen to notice there's been a decline in my sales during that time. I'm just going to hold you, here's the math. It's just my last year's versus this year's. You're 100% responsible. No consideration for any other factors, no consideration for, frankly, some of the time frames that were going on. COVID was still impacting sales, no consideration to anything other than that. It was just pure math. But that's what they said was their model. They gave us a number, I think, about $150,000 or so. We never treated that as a serious number, frankly. We don't think it was a supportable model, but that was their calculation.
And then you mentioned she registered some copyrights before the lawsuit was filed. Is there a mechanism to challenge those copyrights with the Copyright Office separate and aside from what you're doing in the lawsuit?
That wasn't something that we explored in this case. Our focus was pretty solely on that side of it. I do believe there is, but really that wasn't our focus because part of the way, at least where you invalidate them is you prove the lack of originality at the trial court. It's the trial court who decides you failed to meet the requirements for actual registration. So I don't know what happens to the filing that you filed there. It might still be in their records, but they decide it's not a protectable or enforceable right.
Yeah. Okay. So y'all immediately file a motion to dismiss after you get in the case?
That's right. We initially challenged, I think, 6 out of the 8 claims. It was granted half and half, 3 dismissed, 3 weren't. The interesting thing, right, is that most of the case was about infringement and about this trade dress. We didn't actually choose to challenge those, in part because we thought, I think correctly, and a lot of legal scholars sort of commented on this, the law wasn't in a good place, and frankly, it still isn't in a good place to knock these cases out of court early. you can still articulate the essence of copyright, at least in words, in this new social media landscape, and, potentially state a claim that isn't going to get knocked out immediately because the law hasn't caught up to it. Most of the cases that you are looking at there's a handful in social media, but there's literal print photography. You're looking at cases about books, and it doesn't necessarily keep up and translate in a way that we thought would resonate with a court, and that we'd be able to have, here's that case. This is it. This was the first of its kind.
Got it. Okay, so magistrate judge writes a report and recommendation to the district judge saying, I think these should be dismissed and these should not. And the district judge adopted that report or those recommendations.
That's right. The magistrate judge, it was all of those preempted claims, pretty clearly and correctly just said these are out in this case. So tortious interference, unfair competition, unjust enrichment, those were immediately out of the case. And then went against us on, vicarious infringement, the DMCA removal of CMI, and the likeness claim. The interesting thing is I can't blame the judge. I have my own disagreements, of course, but I can't really blame the judge, at least on the likeness one. We said there are pictures in the complaint and you should just look at them. There is, at least in federal court, this plausibility standard, and it isn't even plausible to look at these pictures and say, here are two women side by side that do not look alike. People truly cannot tell the difference.
And when you say plausibility, are you talking about pleading? Like, you can plead anything. Anyone can file a lawsuit and say anything, but there's a case called Twombly.
Iqbal and Twombly, right.
Yeah, that you have to be more specific, but there's a test is kind of with that, the plausibility, meaning you can't just say ridiculous stuff. It's got to have some semblance of plausibility.
That's right. And, that's contrasted to, I recently had a motion to dismiss in California state court. Texas were similar, just pure notice pleading, where the court will say, we don't care that you've said something ridiculous. You'll have your chance to prove it soon. Have you said the right words in the right order, that if they're all true and we don't even think about it, can that state a claim? Federal court, little higher bar, some wiggle room, depending on how much the judge, wants to lean into it. And I think that's what sort of counseled the judge to go against us on that one, is that this truly was the first case of its kind. I think they were interested to, see if the law would develop here, let some more facts and record, develop. Unfortunately, when a case just ends with a non-suit, you don't develop the law. So it doesn't help people out, other than, people are aware that the outcome of this case.
Got it. And then, so after that ruling, were there any depositions ever taken?
So there weren't. The depositions for the plaintiff were imminent. We had noticed them. I think we had booked our flights. So initially, both of these women were in Austin, Texas. That's how they got to know each other. They met twice, actually meeting up at the mall. And then the plaintiff, Sydney, moved up to Minneapolis. So the depositions were imminent. We were deposing her mom, her fiance, and we're not the type of lawyers to just go, hey, let's depose everyone in your family and sort of use this as a hammer. But the problem was, we asked her, well, you say you're famous. You say that you're original. You say that you have these known characteristics that you're famous for, even down to her manner of speaking, completely unique. Tell us who we can talk to learn why you're so special. Well, she says, the people who think I'm special are my mom, my fiance, and my sister. And my family thinks I'm special too.
Yeah.
But we said, fair enough.
Mine kind of does.
We'll go ask them. And turns out, maybe that was what finally got us to convince her to drop the case, was seeing that was imminent. But right before depositions were set to happen, she did ask us for permission to drop the case.
So you guys had mediated it with former Judge Patrick Keel?
That's right. Judge Keel, I think we had mediated with him about 6 weeks prior. Obviously, I can't get into everything in the mediation, but he did a great job. We were very happy to work with him.
Good. And so y'all were set for that, and then just out of nowhere, you get a call or an email from her lawyer asking because in federal court, you have to have permission from the defendant after an answer's been filed. I think the answer is what triggers it to just, in state court, you can just file a non-suit even in the middle of trial.
Right.
With just, yeah.
I think you don't even have to file it. We actually had a case on this recently. If you speak the words out loud, the non-suit has instantaneous effect, which is interesting that became an issue. But there's a Supreme Court case on that.
Yeah.
So magic words can happen during a trial.
But in this case,
that's right. Yeah, federal court. Since there had been some progression, they had to ask us for permission. You can't just drop the case. And so it was maybe 6 weeks after the mediation. Depositions were imminent to happen. And they had also been a change in counsel, or rather an addition of counsel. Ms. Gifford had hired additional counsel from Perky Barber. Obviously, I can't speculate as to what new perspectives, they brought to the case, but
Perky Barber is known as one of the best trademark firms. Fair?
Absolutely. I think she probably received some very good advice shortly after they joined the case, which is part of why she dropped it.
Yeah. Was there a formal settlement agreement?
There was. It was pretty straightforward. It's not confidential. That for us in, our communications, even a month into the case, we had some non-starters. The big thing is for our client, her brand and her living is her reputation. So, most settlement agreements I've ever entered, as much as I hate entering settlement agreements, most that I've ever entered are confidential.
Mm-hmm.
For us, that's an immediate non-starter here. We also weren't going to agree to any sort of, non-disparagement or any sort of hook that you could claim was a violation of the agreement, because there was a lot of distrust. We didn't want, this was a hard case for the plaintiff because it wasn't based in the facts and law. We didn't want to give them an easy later case of, well, you might have violated the letter of a contract. So we wouldn't agree to anything in the contract that could potentially be violated. And ultimately, the settlement agreement here was full non-suit by the plaintiff. We would pay nothing, and we would have the full right to tell the story after the fact. So, a lot of media did report it formally, I think, as a settlement agreement. We've been pretty aggressive. It's not really a settlement when we didn't have counterclaims.
Yeah.
It was a non-suit and a total defense win.
Yeah, well, we had another lawyer on who talked about a trial that was like over low amount of money that ended up with, multiple hundreds of thousands in legal fees, and because it went to trial. And I asked him, like, at what point did it stop being about the money and be personal? Because I will give Miss Gifford or Sloan now credit in that at least she recognized at some point this isn't a good idea anymore.
Absolutely. And, again, I don't like to get in someone's head or speculate, and I don't want to disparage anything, because I think she ultimately did make the right choice, which was to give up this, frivolous lawsuit. Part of the reason she hadn't been deposed yet was she had a kid. It was earlier in the year, and so we were happy to accommodate, we'll do your deposition later. And we kind of sat back with the hope and, had a conversation. Look, she's just having a kid. She's a new mom. Maybe she gets a fresh perspective on this, because, this was a case that wasn't really about the dollars. There were definitely personalities involved, for our client too. I'm sure it would have been cheaper. And, we had conversations the way that you do with every client of, look, if you want to open up the checkbook, can you maybe make something go away? But what do you give up in terms of your reputation, in terms of your ability to say that you were in the right? We had offers of, pay us some money. This is confidential. You're not allowed to do something anymore. Well, we couldn't do that. So absolutely credit where it's due. We appreciate her change of heart.
Yeah. Well, I mean, credit to your client too, because a lot of people would have done just that. This is a pain. I don't want to go through this. I'm scared. A lot of people are scared of getting sued, and just written a check and done some, bad deal. And she hired top flight lawyers and fought it. I'm sure it wasn't cheap for her, but she fought it and won.
This was the thing that was probably the most exciting to get to represent her, because, a lot of the times we're large, we have 50 lawyers, a pretty sizable law firm. A lot of the times we're representing corporations who have the pockets, but who also the case is about money. And at the end of the day, it's a check that's on the line. This is different. It was her reputation, and it was, her personally making decisions about what does she want to stand for. And, the big thing for her is, she is, when this suit started, or, the initial fact, she was 21 years old. She has built an incredibly successful brand and reputation for herself. She's made a great living now in a way that, a lot of people, when talking about this case, kind of denigrated influencers in general. They're like, well, isn't this ridiculous? What are influencers suing each other for? But they do important work. There's a reason they get paid very well by these companies to drive social media and engagement. And she had really built something for herself. And, she wanted to stand up for the other women who aren't exactly in the fortunate position to be able to afford a law firm like us, to be able to afford to fight this out. She said, I'm in the right here. I know that I am. And I want people to not have to worry about getting bullied out of the industry like this. And it was really a privilege to represent her.
Yeah, well, good. 21. She was 21?
I think she's maybe 23 now.
Yeah.
But it was pretty awesome. And fearless. That was the exciting thing too. She took a very active role. There were times where we're texting back and forth pretty late at night of like, I don't know any of this stuff. Like, why was this particular swimsuit popular at this time? Boom. Here is where it was initially like some celebrity that I don't know wore a swimsuit in Cancun in April. And then this was the emulated of that. And here's 15 other people who advertised it before either of us did.
So she knows her industry.
She knew her industry, and she knew her truth. So she took a very active role in that, and that's always great to get to work with.
Yeah. Well, products have always been sold either directly by the whoever makes it, or with indirect channels. Where you have and they're just an indirect sales channel. It sounds like
right. Well, that's, to us, it kind of was that same thing. We keep going back. H-E-B and Walmart are both allowed to sell the same soda. They're allowed to sell the same bags of chips. And there's not a monopoly for thinking to sell Doritos at a grocery store.
Yeah.
There's not a monopoly for thinking to sell Amazon products here, especially when Amazon put those products in both of their inboxes and said, hey, we'd love for you to advertise them.
Okay. Your trial team, you met Shamir, Shamir's last name?
Halapoda.
Okay.
And then Jason McManus. And then we also had Sujith Ravelo. So we had a sizable trial team. If this case ended up gearing up, obviously not all of us were, going full speed on this the whole time. But if the trial had gone forward, that was the plan. All four of us had even picked out beige suits we were hoping to wear.
Oh, nice. Sad beige or happy beige?
Different flavors of beige. You got beige, you got tan, cream. It was going to be fun.
Yeah. But Shamir gets the credit for the Beyonce quote at the beginning of your answer.
Oh, for sure. Shamir gets a lot of credit for, some of the creative phrases. He really knows how to turn a phrase.
Yeah.
Adds that extra punch to things.
Well, good. Well, congratulations on that, Thomas. That you rarely hear of a win that convincing, but more importantly to your client. I know there's legal fees, but it was done early. Not only because that means lower legal fees, but also for her. Clients, we do this, or I don't anymore, but you guys do this every day. So you're used to being in litigation, but clients aren't, and it's stressful. And so you got that done for her within less than a year, roughly a year?
Just about a year. It was, I think, a year and a month before it was inked. And that was, I think, the nicest, most satisfying thing of all was to, bring peace to this, because again, this is a young woman. Most of the time, even when a company is involved, you're working with the corporate counsel. Some of them are involved day to day with the lawsuit, but it's not consuming their life. She was being harassed by people online, and I'm sure there'll still always be people out there who have some nasty comments, right? Both of these women have people in their spheres that no matter what one or the other says, it's almost like politics. You're not going to convince anyone. There are going to be some nasty comments back and forth. she received quite a few after the plaintiff put her allegations out there. Our hope, of course, is we brought some peace to that, especially after she's been able to pretty triumphantly say that this just was not based in reality.
Well, good. Well, yeah, this was great. And I can't decide if I am happy or sad that Kyle and Bill weren't here. Probably sad because, but this is very informative and mostly everything you've said has been great. So thank you.
Absolutely. I appreciate the invitation. This is, like I said, when we were talking earlier, first time I've ever been reached out for a podcast for one of my suits. This was probably my highest profile case in a way I never could have expected when it first came in the door. I've learned more media training and talking to news reporters and agents than any other case before.
Well, first of many to come for you, I'm sure. Okay, well, obviously AZA law firm, easy to find online, every social media channel. You can find Thomas's bio there and the rest of his trial team. And for us, you can follow us on YouTube, Spotify, Facebook, Instagram, TikTok, and LinkedIn.
Great.
Among others. So thanks for joining us, and we will see you next week.
Thank you very much.